Good morning. I'm Attorney General Eric Schneiderman. Thank you for being here. I'm joined today by Josh Zinner, the co-director for New Economy Project, Megan Fox, attorney with South Brooklyn Legal Services, and Shabnam Faruqi from Staten Island Legal Services. South Brooklyn Legal Services and Staten Island Legal Services are both part of our homeowner protection program. They're both grantees of this office. One of the reasons New York homeowners have done better than homeowners in pretty much any other state is that we started out using settlement funds, which we obtained under the National Mortgage Servicing Settlement, to finance legal services and housing counseling all around the state. It is my hope and my intent that no New Yorker ever has to face a bank in renegotiating their mortgage and trying to save their home without access to a housing counselor or an attorney. And the folks who are up here with me have been working hard helping thousands of New York families over the course of the last year. Today we're here because we need some extra help from the banks to make sure that the National Mortgage Servicing Settlement is doing what it was intended to do. This past May, I announced my intention to pursue a legal action against two banks that had the worst records of violating the servicing standards set forth in the National Mortgage Servicing Settlement, Bank of America and Wells Fargo. We received complaints from our HOP network of service providers who are all over the state and really help us track the violations, and it became clear to us that these two banks were doing worse and having more problems than the other banks that signed onto the settlement. So the servicing standards are one of the most important parts of the settlement agreement, and I held out in 2011 for modifications to the servicing agreement to ensure that we were able to obtain immediate relief for homeowners, and that the things like our HOP program were going to be possible. Also to preserve our additional claims for conduct that caused the bubble and crash of the economy. The banks did not give up those claims. There are negotiations underway with one institution right now to resolve those claims, and we will have more relief for homeowners coming, I believe, as a result of that. And finally, to make sure that we had detailed servicing standards that would ensure that homeowners got access to the principal reductions, rate reductions, and other things offered under the settlement. The most critical standards relate to time. They relate to the deadlines for the bank's ability to delay a homeowner and push off the resolution of their efforts to get a loan modification. In this case, the Rolling Stones were wrong. Time is not on our side. If you are a homeowner and your efforts to modify your mortgage are being delayed, fees and penalties mount up, and it becomes harder and harder to get yourself out from underwater. Since we wrote our letter to the two banks and gave notice of intent to sue, they've taken radically different courses. One, Bank of America chose to acknowledge the problems, work with us to develop very practical solutions to them, and to enter into a written agreement with us to impose additional standards to make sure that the homeowners get the relief that they were intended to get under the National Mortgage Settlement. Under the terms of our agreement with Bank of America, which we're very pleased that they have entered into, they will assign high-level decision makers to all HOP counselors and legal service providers, because people are tired of negotiating with staff that doesn't actually have the authority to close the deal and move on, which banks frequently put out because they don't want to hire more senior people, perhaps. Now, Bank of America has agreed to designate staff with the authority to make decisions. They are revising their missing documents letter in consultation with our office to ensure clear communication with borrowers. This is tremendously important, as I will explain later in the context of Wells. They also are assigning loan underwriters, specialized staff, when they receive notice from a HOP legal services or housing counselor that there is a homeowner with complex or non-traditional sources of income. This is a big hang-up. Sometimes they have boxes that if you don't fit into the boxes, you don't get through on a loan mod. They're going to assign underwriters to make sure that happens. Fourth, they're going to permit the borrower's attorneys to deal directly with Bank of America staff if they have problems with outside counsel. We have numerous reports of outside law firms, again, not really having the authority to close a deal and not even understanding the process. Perhaps most significantly, the Bank of America has agreed to stop selling loan servicing contracts to other firms for mortgages that are under review for modifications by the bank. You can no longer avoid a loan modification that you're in the process of negotiating by selling a servicing contract to someone else under this agreement. It's tremendously significant. And finally, for borrowers who have a change in financial circumstances, in the course of the negotiations, they're going to have another opportunity to submit their changed circumstances before a loan mod is denied. We're giving Bank of America, and they've agreed to this, 120 days to implement these changes. If they are not implemented, if it doesn't seem to be moving along to our satisfaction, our right to pursue them in court is still there, and we have their agreement to provide regular reports, and they are working with our office on the practical mechanisms to ensure that these revised procedures are implemented effectively and quickly, and we look forward to thousands and thousands of New York homeowners benefiting from these changes. Wells Fargo chose a very different course. They essentially have refused to acknowledge that they have a problem. They've refused to enter into a signed agreement with reporting requirements, with deadlines, and they, in fact, all they did was send a letter, one letter to me and one to the National Mortgage Settlement Monitoring Committee, offering voluntary help or voluntary changes, and not even acknowledging that their procedures have problems. Their communication with customers is terrible, that they're not providing the right folks with the ability to close a deal, and that they are selling servicing contracts so that the homeowners have to start all over again with the new servicer. Their letters say things like, we've continued to review our process and procedures, and we have identified voluntary operational strategies to enhance the borrower experience. None of this provides any relief or even acknowledges that they have engaged in any misconduct. So we are proceeding to file a motion in the Federal District Court of the District of Columbia as soon as they are open for business. And there is nothing that stops them from coming forward and negotiating something like the Bank of America did. And frankly, their offer of voluntary changes and no deadlines and no specific procedures or policies is simply not good enough. Wells Fargo has been, if not certainly one of the most difficult banks all across America in dealing with homeowners. They claim that they are working to make things clear. Let me read you a portion of a letter that was sent by Wells Fargo this year to a homeowner. Your REs are present on 2011 taxes IAO 4,250, period. Is B1 claiming unuried during the year, question mark? If so, how much per pay period? 2, new HAMP requirement per FRI 32213 needs separate hardship affidavit S and D for B2 only, period. 3, the holiday pay for uniform forces IAO 1936-38, is this pay for New Year's only, or is this paid symbol of a triangle? One time per year, question mark, for PG2 of MCU, BNK, STMT has large depositiao. It looks like they're trying to write deposit in mock Italian. Depositiao, 5,830. What is this? Is this recurring or one time? 5 is BWR, paying on any of the liens, judgment, Sun, CBR, judgment IAO, 1,576 civil court, New York Richmond BCH judgment, IAO 1,800, civil court NY Richmond BCH judgment, IAO 2,344, civil court Richmond BCH. If so, Mo. much per month, question mark. So I appreciate their efforts at honoring the diversity of New York and the fact that they are looking out for the Martian-speaking population of homeowners. But honestly, if a homeowner gets letters like this from Wells Fargo, how are they supposed to know what to do? This is the kind of conduct that they say is not a problem. And we're moving against them in court to ensure that they do modify their mode of communications with customers, as Bank of America has agreed to do. They do have officers designate who can close a deal and move on, that they stop selling servicing contracts on mortgages where there is a loan modification underway, and the other remedies that Bank of America has thought through, worked out, and is going to be complying with. I think that the action we're taking against Wells Fargo and the deal we've announced with Bank of America, and also, let me note, the actions taken today by the Monitoring Committee for the National Mortgage Settlement, who are issuing some new metrics, and Bank of America has worked with us as well as with the National Mortgage Settlement Monitoring Committee in developing these procedures. So this is not something that cannot be replicated in other places, but my first focus is on struggling New York homeowners, and we are confident that thousands of them will receive additional relief, will suffer less through this Byzantine process where people are forced to submit documents over and over again. They get incomprehensible communications, and they're faced often with people who either don't understand the process or simply do not have the authority to close a deal. Both of these cases send a strong message that the national mortgage settlement is not to be taken lightly. We are proceeding to enforce it. We are proceeding on the other fronts that were preserved by the draft of the settlement the banks entered into, where I retained, and the working group that I co-chair retained the ability to pursue banks for pre-crash misconduct. But today is all about helping New York homeowners, recognizing one bank that has done the right thing and one bank that refuses to even acknowledge that they have a problem. And with that, I will turn it over to Josh Zinner from the New Economy Project. For more than a decade, Josh has been a leader in advocacy for victims of abusive and discriminatory lending practices, and he's going to speak with us now.